It is 6 o'clock on May 27. I'd like to call this special meeting of the Old Saybrook Zoning Board of Appeals to order. As is our custom, please stand and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Roll call, members present. Kevin Dandy, Vice Chair. Marty Ladd. Here. Andrew Morosky. Here. Jonathan Miles. Here. Laurie Benin. Here. And myself, Alfred Wilcox, Chair. We have a very unusual agenda tonight. Happily, I can say it's unusual because it's very rare that we have an applicant who presents to us a proposal and then departs from it after we've granted a variance. And the question is, as I see it, what do we do about it? There's an interesting question that some of the correspondence from Ms. Shansky has raised, which is what does the zoning officer, the zoning enforcement officer, do about it? We can't speak to that, in my opinion. To me, that is a legal question that our counsel and the applicant's counsel can discuss, and if they can't agree, I suppose a court might have to decide it. But my view is that, Nick, unless you tell me I'm completely wrong in this, I don't think we have anything to do with that question. Do you disagree?
I'd reframe it a little bit. I mean, the main reason why this item is in front of the ZBA this evening is to clarify whether there was a condition effectively on your prior variance approval or not, and whether this alleged deviation constitutes a violation of such a condition if there ever was that intention of the board that the foundation and the basement remain in some configuration.
Okay.
And the answer to that question really informs what the zoning enforcement officer's authority would be in this context to pursue zoning enforcement. If there's a violation of a condition of a variance, there's grounds for enforcement. If there isn't, there's no enforcement.
Okay. Let's break that down if we can. I think it is abundantly clear that there was no express condition expressed in the motion or in the vote. However, I think the question also is, can we rely on what people represent to us? And would it make any difference to us if we had known in the prior hearing that the entire foundation was going to be torn down? I think that's the issue before. Would it have made a difference? And there are really two parts to that. One is, would it have had any impact on our deliberations? And if so, would it have any impact on our final decision? I don't know if we want to spend time talking about whether it would have affected our deliberations. I know it would have affected the arguments I made and the arguments I chose not to make. I relied on the representation that this was a full basement and that it would be used to the fullest extent possible, and not wishing to undermine lateral support, not wishing to create rubble that didn't have to be created, not wishing to impose added expense. I refrained from addressing other arguments made as to the justification for not centering the house and thereby eliminating the non-conforming eastern setback. I raised the issue, why don't we do it? And among other reasons that were advanced during the course of the meeting was, we're using the existing foundation. So, to me, that it certainly affected the deliberations, and it didn't affect my vote because I voted on other grounds to reject it. But it did affect the arguments that I advanced to the other commissioners, other board members. And I yield the floor to whoever would like to speak. Kevin?
You know, this meeting took 2 months. There was a lot of evidence. So to review it months and months later, 6 months, whatever it's been, you know, it was time consuming, because how do you recreate your thought process during that time? Which maybe it's possible, maybe it's not. To be ready for tonight, I read quite a bit of the old testimony and what was available. I visited the site. Well, we all visited the site last month when they applied for a variance and for some reason withdrew. But also what I did is I went back there. The 2 meetings were available on YouTube. I watched them both. Actually, I had watched November in preparation for the last appeal to refresh my memory. I never got to October because they withdrew. This month, I went through both of them again. And what I found interesting was in the October meeting, there were actually 6 times that the foundation staying was referenced. And surprisingly, in November, none. But as far as, does that make a difference? It probably does, but at least for me, to get to the point of wanting to grant a variance, the evidence is incremental. Everything means something. Some are pluses, some are minuses. So yes, there are, changes in nonconformities, eliminations, and reductions. But what's clear to me is that the reason we were part of the reason we were allowing them and granting a variance was because they're existing on that foundation. When you go out there, and I found it also interesting that, yes, I understand why there's a fence there, but we're so concerned about the views, we covered everything up so nobody can see what's going in there. So I went around it. Whether I was supposed to or not, I did. And here we go. Let's say this piece of paper is your empty lot. Let's say this is along C Lane. This lady on this side, it's close to hers, not as close over here. So if you're going to take the entire structure out, why wouldn't anybody want to center it? And what would the hardship be? That's what we're being asked tonight. What if? Well, we don't know what if. I don't know if they, if there was new evidence that would have been presented a month ago that they chose not to bring forward. So I really can't tell you. I can tell you that the fact that 6 times in the October meeting, it was spoken about, and November is nothing. So that kind of bothers me. And what happened, I don't really care what happened. But I think at one point, I think that we're dealing with people that are educated people that understand what went on at the hearings, whether it's the developers, the attorneys, or whatever. When the attorney stands there, whether they're under oath or not, and they say for 6 times that that's going to remain, we understand that that's going to remain. Because the motion didn't have the condition that the foundation shall remain, I mean, it was clear as day. It wasn't something that was glossed over. It was spoken about in depth. So that's where I'm at. And I don't know if they came before us. I don't know what the outcome's going to be because I haven't seen the evidence. And as much as I'd like to say that I think that we should, that I thought something differently, I'm not going to say that because that's just not the truth. Like I say, everything is incremental. That meant something as well as other things. And whether that put it over the top or something else put it over the top, I can't honestly tell you 6 months later.
I just wanted to add a footnote, 2 things. I asked 2 different questions at the meeting, the November meeting.
Yeah.
And one was, why don't you center it?
I remember
And
hearing.
the other was, is this a full basement?
Yes, you did.
And the answer was, yes, it is. So clearly there were.
Well, I have no problem. It's full basement. Good for you.
Yeah.
I mean, I have no problem with that. I don't care what you do in the basement.
Right.
But I also think that we need to respect the regulations where, they were getting accommodated with the variance because the foundation was existing that close to the line. Well, the lady next door, if it's a clean slate, why doesn't she get the opportunity to benefit by the regulations? You know, I think everybody needs to benefit. We're concerned about people's views and so forth. So if it moves one way or the other, first off, that's not our charge anyway. But in reality, if the house moves one way or the other, one person's going to benefit, another isn't going to benefit. My particular instance at my house, I've had two people over the years build two different structures, and good for them. I understand why they want to look at the water. Good for them.
Yeah.
You know, it's taken my view away, but that's life.
To Kevin's point, the 6 times in the October meeting, I'm not necessarily sure I was seated for that one or even it, but the November meeting specifically, the inherent understanding was that the basement was remaining. It's as simple as that, pretty black and white for me.
It was in the written application materials a couple different ways.
Right.
I'll just make one comment. I think if a condition is necessary to an approval, it would be based on something that's discussed at the hearing in particularity and is either was thought to be changing, that we said, no, it can't, or was a requirement remain the same. And I don't think the basement was an issue for discussion in terms of it moving. It was something that was not considered as requiring a condition. And I think that just opens a door to a whole host of issues if we have to condition every approval on everything staying the same and enunciate what they would be, because that's really the only way to effectively make sure we're covering bases.
You're never going to cover everything. You mean,
Right.
you want to believe the people that are testifying in front of
You
you.
have to go on what
And
you're
I'm not
given in
saying that-
totality.
I don't know what happened with this foundation wall.
Correct.
It's irrelevant to me.
Right.
But when it went away, I think it changes things. And if they feel strongly and they want to come before the board again for a variance, they can. They could. They applied and they withdrew.
Right.
So I mean, our attorney, he probably has something to say about this, but
We're not open yet.
We're not open yet.
At the appropriate time, I'd like to address the board.
Andrew?
I wasn't seated for the hearing, but
Okay.
In terms of the walls, my feeling is they kept the same footprint. I went back and looked and I saw the board's footprint. That stayed the same, and they had to reconstruct some of the walls. To me, it doesn't make a difference if you had to reconstruct it completely, but as long as it was in the same place, then you're meeting the spirit of the approval.
Marty?
I remember the discussions, and if I understood the applicant's response was that the outside of the foundation was remaining, and they were widening it, but they were doing it internal to support the structure, the house that they were building. So I'd like to hear more from the applicants about that before I can say something tonight.
Okay. Well,
Can we also put on the record what has changed, if anything? If it was demolished to the exact same, is it the same dimensions? Is everything the same between the new foundation and the old as at the time of the application, or we're comparing apples to oranges?
I also want to know
We
why.
know.
From a construction standpoint, I want to know why. Because in November, we voted for one, Chubb was, voted no.
Mhm.
Why? There has to be some constructability that says to somebody,
Right.
without coming back in front of us to modify the variance. I want to know why.
And at that time, why was it not
Right.
brought up? as a potential issue.
And then
that
my
no one
brain
was aware
starts
at that
going
time.
back to what Kevin said. In October, it's, no, we're not taking it out. No, we're not taking it out. No, we're not taking 6 times. November's nothing's mentioned. Now all of a sudden we don't have a foundation in front.
But you know, that it's not, they applied for a variance. And then they withdrew. So what we're just guessing, you know, and it's not our job to guess.
Mhm.
They have an opportunity, they can still come back to ZBA if they choose. Apply for a variance. See where it goes, but yeah, for us to second guess why all this happened is really not our job. It's their
That's
job.
fair,
to prove their-
but I almost feel like it's asking for forgiveness after the fact.
What's the date of demolition?
Right.
Do we have that and specific as to the timing? Maybe they can address that.
Well, not necessarily.
But that's
That's
all.
I mean,
that's
I
all.
I
that's
agree
all
with Kevin.
for another application for a variance and
Yeah. I think the real issue before us, if they come back, is, okay, we have a blank slate here now. Why don't you center the house in the middle of the property and
well, I'm not, see, that's why I don't want to get into what ifs and maybes because I'm not making my mind up. I know what exists, but I don't know what's in everybody's mind.
what
So if they
exists?
want the opportunity to tell us what's on their mind, the way to do that is to apply for a variance and come back before us. If they don't.
Can I jump in here, folks? Can I just jump in briefly? So, I would hazard a guess that the applicants are not going to come back. Really, the question is before the board right now. If the answer is yes, this foundation remaining exactly where it was a condition of the prior variance approval, then in order to avoid being non-compliant, they would need to come back and ask for a formal modification, which would trigger a full public hearing. I do not believe, and I won't speak for Attorney Shansky or whoever may be there on behalf of these prior applicants, but I believe the position is from their side that there is no condition, and therefore there is no formal need to come in with a blank slate. So we are trying to find some way in the current circumstances, knowing that the foundation did not exactly remain, whether that in fact triggers nonconformity with the approvals subject to enforcement, and which would necessitate coming back for a modification, or if that was not intended as a specific condition that, if not met, would have triggered non-compliance and enforcement.
Well, all I can say is, from my perspective, it was a very material factor in my assessment of the variance. Now, since I voted no anyway, because of the third story, in my view, did it affect the way I voted? No. Did it the way I assessed the hearing? Absolutely. I can't say more than that. Did it absolutely affect your assessment of the hearing?
My recollection is that you and I were focused on the third floor,
Yes.
you know, and we went back and forth and probably had a 15 or 20-minute conversation about that. I was not taking into accordance. I took it at face value that the foundation is remaining as is and it's staying where it is and we're building on top of it. So that was a non-issue for me. I was with you on the upper floor and how we interpreted it.
Okay.
So how do I put this? Yes, the knowledge of would it have affected my decision?
If you'd known you were dealing with a blank slate in the ground.
Yeah, it would have.
You know, I can't say that, I can't say, it's incremental for me, you know, I cannot.
It's kind of hypothetical, you know what I mean?
Sorry, that sun is just really.
You know, the other thing is, Burn a hole.
Want a visor? I have a visor.
You know, what would the end result be if they built it? The end result would be that they built what we approved with a new foundation. Okay, so what does case law say if that was allowed?
So ask that. Can you ask that again, Kevin?
Okay, we approve this and like I said, it's incremental. My going up my ladder to approval. You got reduction of nonconformities, elimination of nonconformities. You got a pre-existing foundation that was whatever it is, 8.5 feet from the property line. So if there was something, there's just facts missing at this point. We don't know why the foundation, I don't know. I haven't seen any evidence. Why was the foundation demolished? Why did all this happen? Okay, we haven't heard anything about that. That would have been, if they went forward with their appeal, it would have been nice to know that. At the end of the day, if they built what they said they were gonna build on the footprint they said they were gonna build it on, should it make, I'm asking you, attorney, should it make a difference? And if the answer is no, then I guess that they should be allowed to continue. If there's case law that says, oh no, this isn't what you approved, then they need to apply for the variance. So
This falls in, I mean, literally the reason why we're back is because this falls into a bit of a gray area. So the law is pretty clear that where there's an express condition on the, i.e. on the notice of the decision, the motion, the resolution, then obviously there's clearly a condition. There is some additional case law, which is literally, I have a case that went to the appellate court and it's now pending in front of the Supreme Court, that the question of does a court look to the discussions of a board to determine whether there was an implied condition? That is literally the question that I have in front of the Supreme Court. So I don't have a clear answer as to the extent of what the law says in this situation. It's really... Go on.
the gentleman would like to speak. Are we allowed to?
So, excuse me one second. So we have several people that would like to speak. So I don't know when the chairman wants to,
Oh, we are gonna open it up?
I don't know. That's where,
I'm,
Well, I think we need, this is kind of a, you say gray area. This is 20 years of doing ZBA. I think it's kind of the first time I've seen something like this, which is fine with me. But,
Right, because I mean, really, the question is this something that's enforceable or not? Is the property currently non-compliant with your variance approval because the foundation came out and the proposal now is to put the wall back where it was originally going to be going anyway? The only difference is the foundation's now out.
and the difference that makes is that we have been denied the opportunity to assess this as a blank slate. Because originally, all the representations were, they were building on the existing foundation. So we have been deprived of the opportunity to make that kind of analysis.
Well, to your point, Chuck, if an attorney, Nick, if we could hear, if it's allowable to hear from the applicant or the representative, what happened? That maybe that makes a difference.
Yeah, I mean, I'm not opposed to allowing commentary. I think it's, I mean, I don't know who's there on behalf of the applicant, if there is a representative and they're willing to make statements.
Attorney Shansky is online with her hand raised.
Okay.
The
So
neighbor,
I would
attorney
allow,
is here and neighbors.
yeah, so I would allow Attorney Shansky the opportunity to comment. I would allow the interested neighbors a similar opportunity to comment. This is not an open door to airing any sort of grievances with this property or this project or the personalities. This is literally the only item on this agenda is to make the determination of a condition or not for enforcement purposes. So if there's some other issues that neighbors want to raise or someone wants to raise as far as non-compliance or some problem they see, tonight's not the night. So I'll just say that just to try to keep guardrails on this, but I would afford Attorney Shansky the opportunity to speak.
Chuck, before you go to public, okay, my understanding, and back to Kevin's point from the October meeting, my understanding as a sitting member in November was it was an implied expectation that what they said in October carried through to November, that the foundation was to remain. And I'm still struggling with the fact that now it's gone. So that kind of bothers me.
I think we're all struggling with that.
The question that I would like answered is what happened?
And
Because
Why?
if there was a
Right? No,
if there
no,
was a
why?
structural-
Why it was
yeah,
removed?
if there was a structural problem that they had, I mean, things happen.
Right.
Field changes happen on every job. So if there was something structural that had to be replaced,
we've been told a couple things already. We've been told that there was not sufficient rebar.
Mhm.
We've been told that there was a change in the use of the property inside.
But here's the thing.
It's all post.
Communication with Chris
Thing
and the
for the
building
record.
department.
But one
But
thing
that's how
for
you
the
do it.
record
Yeah.
is that, so anyone watching the approved ZBA file, and it was made live, as well as the withdrawn ZBA file. So I think what we're referring to is what was testimony
Right.
was what was in the withdrawn and granted ZBA applications that were to be, withdrawn one was supposed to go in front of the board. I know many of you reviewed it before it was withdrawn. And then Attorney Shansky did send some emails, and we had a letter from a neighbor. But by adding both of those files into the record, all the testimony was given kind of back to you for tonight. So just when you're referring, that's why, just so I know, you're referring to the previous record.
at some point, if there was a structural problem, I'm guessing there would have been a structural engineer involved. I mean, that's what we need to know.
Right.
We were told minimum of 6 times that it was gonna remain. If something happens during the construction process
Communication.
and that had to be replaced, then of course they should be allowed to replace it and continue. But if they just decided, hey, we want to do something different, well,
It's a problem.
now you got a problem.
Well, I think we would need to hear from the owners, the architect, and the structural engineer to have an answer to that.
Agreed.
Well, is there a way that we could know who's here?
If I could just ask procedurally, are we allowed to have those kinds of discussions? Attorney Bamonte, please clarify that for me. What are we allowed to take under consideration today in addition to the written materials that were forwarded to us prior to the meeting?
I mean, my understanding was that we're deciding whether or not our decision in November would have changed based on what we know now.
Correct. I just wasn't sure how
That's
much
a
we
simple
were able
question.
to take.
So that, that's.
People
the-
have an opportunity, aside from who's currently here, does it turn it into more of a need for a public hearing? If there's additional evidence or anybody's gonna speak to things that weren't in place at that time and are new to even the board members now.
I don't think we should have any bearing on what we discuss or decide tonight.
I think an explanation as to what has transpired that precipitated this whole thing is something that can be discussed and considered for tonight's purposes. If ultimately the board determines that this was a condition, then, like I said earlier, in order to correct the defect, they would need to come back and present to the board at a full public hearing.
Yep.
I appreciate that. Thank you, Attorney Bamonte.
Okay, with that said, Ms. Shansky, how long do you think you will need?
I have to promote her.
And when I say need, I'm urging you not to repeat anything that you've already presented to us.
I would like to be made a participant. I don't want to be a disembodied voice in the room, and I'd like to share my screen.
Hold on, I'm
Yeah.
working on it, Marjorie.
And I need at least 10.
Yes,
You
it's gotta refresh.
You've asked a lot of questions, and I'd like to introduce facts into the record or repeat facts that are already in the record. And let me see. So I'm sharing my screen. Do you see that?
Yes.
Yes.
Okay. Let me first start by saying I'm Attorney Marjorie Shansky, and I represent the Sheshels. And I'm here. I'm sorry.
This isn't, I don't think this is what we're asking.
No, this is not what we're asking. This, you've already given us all this data.
Yes, but it's critical to this, the misrepresentations in the notice that brings you here this evening. And I want to say at the outset that this was a unilateral convening of the ZBA for purposes that are beyond the jurisdictional remit of the ZBA, and we are reserving all rights associated with challenging this process, which seriously violates my client's due process rights and lacks fundamental fairness that is the hallmark of all land use matters. But here we are. And the reason I'm showing this is because for however many repetitions of the representation relating to the retention of the eastern foundation wall, the one that is 8 feet 6 inches off of the property line, it is manifestly untrue that there was representation of preserving the whole foundation. And that is predicated on the basis of the application, which was predicated on reduction and elimination of
Okay, let me interrupt. There is a big excluded middle here. There's a big difference between having one wall and having the entire basement. Everybody would understand that if you're adding to the basement, if you're adding to the house, you're going to be adding to the basement. That's not an issue. But at no time was it ever said to this board that we're only going to keep the easternmost wall of this basement.
It absolutely was. And please look at this chart, which was on the site plan and in my narrative attached to the application. Please look at the line that says street line setback. Your regulations require 20 feet, 25 feet. The existing house was at 23.4 feet. The new house is at 25.1 feet. We eliminated the nonconformity. You can't do that without moving the wall. The rear property line was is required at 15 feet. The existing house was at 40.2, and the proposed house was at 35.9, which is still a conforming dimension. You can't do that without removing the wall. There was no representation about retaining the existing footprint, the existing foundation, because the house was being made more conforming.
Okay.
So
Mark?
the only,
Excuse me.
I'm sorry, could I please have your attention while
No,
I'm
because
speaking?
we're not gonna have a full trial on this tonight. The question that I had asked is, and yes, you did talk about the east wall, preserving the east wall, okay? So the east wall is the one that we're talking about that's been replaced.
Well, except that all of you were referring to the removal of the foundation as being, Mr. Wilcox said, a material factor, but it was never on the table. That is prejudicial to my clients because it is against the evidence that was before you at the time. This is predicated on the
Tell us what happened to the wall, why it was removed. Can you tell us why the wall was removed? Why was the east wall removed?
I will tell you that. When the house went to construction drawings after your November decision, which was not appealed, It became apparent both from a structural investigation and to make it building code compliant that the existing eastern wall, and it would have been true of all of the wall, was not up to code, did not contain rebar, and was not sufficient for the structure being built. I spoke to the building official. Well, let me say that on March 4th, Ms. Costa, the zoning enforcement officer, issued a certificate of zoning compliance on construction plans that showed the new wall. In March, when the building official reviewed the construction plans, he also reviewed the certificate of zoning compliance, and he shared with me that he also reviewed the decision of the zoning board, and he saw no restrictive conditions that had anything to do with retention of the eastern foundation wall. What he saw and the basis on which he issued the building permit was a building code compliance structure, which is sitting in exactly in the location and bearing the bulk signals and the height signals and the use signals that are the approval of this board. So there is no material change. There is a change that was prompted by both the building code and structural needs, and it is the remedy for the removal of the wall is replacement of the wall exactly where it was, and that is the intention is reflected on the plans, and it's only when Mr. Wilcox happened by that he ran to the zoning enforcement officer and claimed that this was not being built in accordance with the decision. I cannot be more emphatic. It is exactly being
Can I ask
built.
you just, let me interrupt you for 1 second. Did you, when they applied for their zoning certificate, did they submit plans with a new foundation?
Yes,
I'm not asking you.
So they submitted plans with their construction drawings. You can look on it. It says ZBA variances that were granted based on the file. I don't know what the building official was referring to. Granted, these are the same plans. The basement was finished, which really doesn't matter, but the testimony and what was approved by this board was that that eastern side of the foundation, that wall, was to remain. That was my understanding of it.
Yeah.
I'm not going to recite the entire variance approval.
Yeah, no. On those plans, is it,
They're the same site plans that you saw with a different plan, but going back to the application, which has maintained the foundation. I assume that that was the intent because that was what was represented.
is there anything on the plans they submitted for the zoning compliance certificate that says that it's a new foundation?
No.
nor does it
And-
say that it's a retained foundation, and it is at a different
So can
internal
we-
dimension than the existing foundation. It's going to be thicker to the inside of the structure. It is a building
So-
code issue.
So when I review variances or applications for certificate of zoning compliances and there's variances, I can only approve the portion that meets the regulation. So when there's a variance, I cite it right on the bottom of the form and it refers back to the full variance file. That variance file and the record for that, including the application form, the testimony at the meeting, was that the basement, I understand the full basement, but mainly the eastern side was to remain.
I see that just for a second. No, I don't, just the certificate that, yes.
There is nothing on the certificate of zoning compliance that says anything about retention of the eastern foundation wall. And
It
there's nothing in
refers
your
to the
approval.
variance
Yeah,
file
it
because I'm
refers
not
to
going to
the-
reiterate
I
everything
know,
in
but-
that or there, and that's why it would be the zoning officer referring to the variances that were granted and writing that down for that approval.
And the building official relied on your certificate of zoning compliance and his own review of the decision.
I don't
And
understand why the building official's reviewing zoning, and I don't understand why the applicant, your clients, didn't come back to this board after the testimony at the meeting that this was going to remain if there was an issue.
Okay, I think we've heard everything we need to hear.
No,
at this
I'm not
point.
done, sir. I'm not done, sir.
I appreciate that you're not done, but I think we might be done.
Well, no, it
With
goes
this.
a little further because my clients received the certificate of zoning compliance, which under the building code and under statute, the building official is required to confirm zoning compliance, and he's entitled to rely on the certificate of zoning compliance.
Okay, right now, what you're doing is asking us to ignore the advice of counsel, which we've just received.
Yes, I am, because
And
counsel
I
is,
understand that, but I don't have to hear more of it. And I
yes, you
don't think
do,
the rest of
sir.
the board needs
Unless
to
you
hear
want to
more of it.
totally deprive my client of their due process rights, you know, if that's where you want to go with it, then we'll just continue this conversation in court, whether federal or state. But Mr. Bamonte lost on the issue of complied condition. It's being reviewed by the Supreme Court. He may lose there as well. So it's not law. It's prospective future law, maybe. It is not binding on this board in any way. You,
Every open question is prospective new law. So
I
that
beg your pardon?
doesn't get us very far.
You don't get to vote
Kevin,
on,
did
you
you
don't
want
get
to
to
say
rely
something?
on future law of indeterminate
Attorney Shansky.
substance. Let me also say that
Okay,
no,
okay, let's cut it off.
in reliance on the issuance of the certificate of zoning compliance
Thank you,
and the building permit.
thank
my
you. Okay, you have been muted. Is there,
Excuse me, folks, I would give Attorney Shansky the opportunity to wrap up her comments.
all right, we'll take your advice. Ms. Jansky, please wrap up.
She need.
No, to wrap up ought to take no more than a minute. We don't want to hear everything you have to say. Just wrap up for us as soon as we get you back sharing.
Sorry, this mouse is terrible.
In the Supreme Court, you get 3 minutes when the light goes on. So
No, you get 20, sir. You get 20.
not when the light goes on.
We got it, there it went.
You're not the Supreme Court.
I know. We're asking you to wrap up.
You are the progenitor of this meeting, this unauthorized meeting, by running to the zoning enforcement officer with your determination, which you stated as you opened the meeting, that the applicant has departed from the approval, a point with which I emphatically disagree, and you are biased. The bulk variances remain unchanged. What you approved by dimension and location and height is what is under construction. The remedy for removing the eastern foundation wall is reinstalling it in the same location. That is what the plans reflect and what will be constructed in accordance with the requirements of the state building code. We established at the time of the variance approval that my client's rights are associated with the law governing reduction and elimination of nonconformities and with the statute itself, Connecticut General Statute 8-2, which protects recreation of nonconforming structures that are recreation and reconstruction of nonconforming structures. And the cases of Petruzzi and Mayor Whitman stand for the proposition that nonconformity is a vested right with a constitutionally protected right for continued existence. The board voted to approve the variances. You are being asked whether or not retaining the existing eastern foundation wall, and not just retaining the location of it, would have influenced your decision about approving the variances. But you didn't discuss that at all in your deliberations, not part of your motion. And it was the case that Member Miles amended Mr. Danby's motion to include the caveat about the cupola being only decorative. So you knew how to attach a condition or a concern if you needed to do so. There's nothing in the November decision that distinguishes between retention of the eastern wall and its replacement in the existing location. It is a distinction without a difference. It is a building code compliant installation that was necessitated structurally and by the current building code. Everything in that record in October, November supported the issuance of the approval of the variances, not to mention the subsequent issuance of the certificate of zoning compliance and the building permit, demolition and commencement of construction. There's nothing in the record that signals the replacement in the same location of the code complying law in any way undermines or alters your approval of the variances. This evening is an unprecedented procedural hurdle that was precipitated unilaterally by Ms. Costa and Attorney Bamonte without our knowledge, agreement, or consent. It takes the ZBA well beyond its limited jurisdiction. We are hopeful that at least 4 members of the board will appreciate the absence of harm to the board's decision by the replacement of the wall in its exact location against the great and burgeoning harm to my clients who have been marking time since Ms. Costa requested that they stop construction in mid-April. It's 6 weeks ago. So council has neither presented a legal basis for this convening, nor has he articulated a decision that is on point with the facts in this case, where nothing in terms of the bulk, height, and location of the structure deviates from what this board approved. The practical
Thank you very much.
way out of this is to permit the Sheshels to carry on. And many of their neighbors who spoke in favor of and wrote letters in favor of this application back in October and November of 2025 agree with that position so that this construction proceeds and they eliminate both the nuisance and disagreeable view that has been created by waiting.
Thank you. Okay.
Kevin's got a question.
Now,
And
was there,
yeah.
Kevin's got a question.
Kevin, did you have a question for?
No, about that gun?
I'm not sure.
How about we give this gentleman an opportunity because he's been
Ms. Shansky,
as well.
when you appear before a board, which you've done probably thousands of times, you expect the board to believe what you tell them, is
I'm so sorry, I don't hear you.
when you appear before a board, you expect the commissioners to believe what you're telling them, don't you?
It's just.
Yes, and I operate on the best information I have at the time. Yes, I do. In fact, I pride myself on being credible.
When you stood before us and on six occasions in the October meeting, you're a smart lady. And I actually really like you because, you've got moxie, as they say. And,
I'm so sorry. It's very hard to hear you.
but when you tell me something 6 times and then you're dancing around it now and you're not showing me a structural engineer's report.
I'm not dancing around it now. Please pull out the site plan. Please look at the zoning chart. You can't reduce a nonconformity without moving a wall. I was talking about the eastern foundation wall, which at the time I understood to be retained. Nobody consulted with me subsequent to November 12th about what the building code issues. I'm neither a designer nor a building official, and what was necessitated by the on-site conditions and the structural needs of the proposed construction. And nobody prepares construction drawings until after they've gone to the board. So yes, I was telling you what I knew as I knew it.
Okay, so you took everybody else's word. There was an architect, there was a surveyor, if they're gonna rebuild on that foundation, somebody had to have an opinion to budget the project, whether they're gonna change their foundation or not. So somebody dropped the ball along the line, in other words, because they didn't recognize that foundation that was built a long time ago wasn't adequate. Or there was.
I can only tell you what I know, which is that during.
Somebody should have known, we're not, this is a expensive project. And whether it's expensive or not, somebody's needs to know if that foundation is gonna work or not before you start. come
In
to
my,
that conclusion. You don't come to that conclusion after you've taken the house down.
Right.
in my 40 years of experience, it is the case that construction drawings are not prepared at the zoning board of appeals level. Because if you don't get the relief, why would you do all of the rest of it and the code compliance?
Diligence, why is that
Yes.
the ZBA's problem?
There's nothing changing here except the wall. The composition of the
Except
wall.
the wall that you mentioned 6 times.
But the wall is in the
Hold on.
location
Mark.
that's approved, and that's your jurisdiction, the location of the wall.
The wall, you believed and you sold us on the fact that the wall at 48 minutes and 5 seconds, 50 minutes and 31 seconds, 51 minutes and 33 seconds, 52 minutes and 35 seconds, 53 minutes and 50 seconds, and 55 minutes and 31 seconds at the October meeting, that east wall was going to remain.
Correct. So
And
let's note 2 things about that.
Zero.
Let's note 2 things about that. One, it was about the eastern wall. It was not about the entire foundation. So please correct that impression in your minds.
It is the eastern wall we're talking
But
about.
let me also say that I'm the lawyer. I'm not the house designer. I'm not the engineer. I'm not the structural engineer. I'm not the building official. And nobody consults with me after the
That's not my
zoning.
problem.
Well, but there's nothing changed about the structure, sir.
But, you know, if someone didn't do their due diligence, it's not us. It's somebody in your group that didn't do their due diligence to find out if that foundation was sufficient to begin with.
As you said earlier, there are a lot of things that are discovered in the construction process. And this is a site change that occurred based on the further examination. And, you know, frankly,
To find out if the house
that
is
the wall,
built on a
that-
foundation, you know, not building on a cloud.
I'm sorry, could you stay closer to the microphone? You're all muffled.
You're building on a foundation, you're not building on a cloud. Of course, that's gonna be one of the first steps. Is that foundation adequate to hold the next structure that's gonna be on there?
From
And
a
if-
zoning
if someone-
perspective,
Your group didn't do that, and that's where you should be pointing the finger, not at the ZBA.
Ma'am, quick question. When was it determined that the east wall was insufficient structurally? Can you tell me that?
sometime between November and March, when the certificate of zoning compliance was filed. And
Okay, fair. So when it was determined by the structural engineer that the east wall foundation was insufficient to support the structure that the architect designed, why wasn't there any communication either with the building department or the zoning official to make us aware, the town officials aware that there was an issue that may raise a problem with the variances that we approved in November?
it was not a condition of approval.
Sorry, Mark.
You see it that way. I see it a different way.
Okay.
It was an implied expectation that wall was remaining based on your statements in October.
Well, that's language that you have been suggested is dispositive. And I'm suggesting to you that if you thought that much about it, that you should have included it, because we're not mind readers.
Well, like, you know, March, sometimes it takes a third party to decide things, and this may be the case.
All right, now, sorry, you've been very patient, sir. I hope you can be equally brief.
I will be as brief as I can, and I will try to keep to the issues before the board. My name is Greg Pietzi. I'm a land use lawyer in Farmington. I represent the Waldens. The Waldens, the last thing they want to be doing is being here having the high road. They didn't ask for this. They certainly
I'm
didn't.
so sorry. I can't hear this gentleman at all.
You mind if I come to the table and close to the microphone?
No. Reach in.
Again, my name is Greg Pietzi. I represent the Waldens. The Waldens are the immediate abutters that are statutorily aggrieved. They are the ones that are 8.6 feet from the property line. They are the ones that are most directly affected, and they didn't ask for this. They didn't want to have to hire a land use lawyer. They were brought into this by what happened on the site. Now, keeping to the issues before the board that were raised by Attorney Pamonte, was there a condition? Well, let's start, and I know the board knows this, okay? But in addition to the representations that were made at the hearing, the application form says, quote, the eastern portion of the new building will be constructed on the existing building's foundation. There's an attachment to that says that the applicants seek to reconstruct an existing non-conforming single-family residence to create a smaller home largely on the existing foundation. There was also, as the board knows, and I listened to it, a lot of representations during the testimony. You'll also note that the plans, which are in the record, conveniently do not show anything below grade. So the question presented in the first instance is whether or not these application materials, these submissions, the representation of council, the plans are conditions of approval. And I would respectfully suggest to your council that it's not as gray as some may think. The case of Anatra versus Zoning Board of Appeals of Madison, this is a state Supreme Court decision from 2013. The citation is 307 Connecticut 728. At page 747 of that decision, the question presented in the case was whether or not the certificate of variance, the one pager that's reported on the land records, needs to incorporate all the conditions of approval. And in this decision, the Supreme Court said, no, it makes more sense to treat a certificate of variance as a notice to all those searching the land records that further investigation should be undertaken by reviewing the administrative file. It goes on to say, consistent with our precedent, the condition should be construed not only by examining the language contained in the certificate of variance, but by considering the entire public record, including the variance application, the accompanying plans and exhibits, the minutes or hearing transcript, and the record of decision. What was the year of that decision? That's a 2013 decision from the state Supreme Court, and effectively overruling the Dotson Boatyard case out of, I believe, Stone. So our position is clear. This, of course, is a condition of approval. You cannot come and make misrepresentations to a zoning board of appeals about what you plan to do and then change in the. And it's not just about the board. My clients are statutorily aggrieved. Now, they were under the impression that all of this work was going to be above grade. Would they perhaps have done something differently if this massive excavation project was going to be happening just feet from the property line? Yeah, they're entitled to rely too on what they said, because this prejudices their rights. There's a lot of talk about fundamental fairness. It's not fundamental fairness to neighbors who are 8.6 feet from this house to say one thing to the board, conveniently let an appeal period lapse, and then completely change everything that they're going to do. That is not fundamental fairness.
In fairness, they're not completely changing.
Well, this raises another point, and I understand and I agree that the procedural posture of tonight's meeting is a little bit unusual. If they said they were going to demolish and replace, I would respectfully suggest that this board would undertake a bit more inquiry. Are you in fact rebuilding what is there? What was there? Are there pictures? Have you surveyed what is at grade? What is a foundation? How deep is the foundation? And I would present to you, and at the appropriate time, when has to be a public hearing or a court hearing, a public record is the assessor's record, which indicates that the rear, and I'm talking about the water side porch, is slab on grade. The Realtor.com pictures, which are publicly available, have photos of that, which also appear to be slab on grade. But when you go into the application materials from the application from last month, they propose to excavate below what had been a porch on grade and add a spa and a gym. Maybe it's a sauna and a gym. I don't know how many gyms are in this house, 2 or 3. So this is all publicly available and ought to be introduced into the record. Now, why is this important? This is important because section 10.7.1 is directly on point. This is the zoning regulation. It states that no non-conforming building, which this is, or other structure or improvement will be enlarged, extended, reconstructed, or structurally altered unless the enlargement or extension is conforming. So the question presented to the board last fall was, is this new house an enlargement? And they represented not. They cited a line of case law, the Hescock decision, which stands for the proposition if all you're doing is removing or lessening nonconformity, you don't need to demonstrate a hardship. That was their pitch. If you go back to Attorney Shansky's memo from, I have it here somewhere in October, this was what they were relying on. And if you look at your minutes, you actually did not find that there was a hardship. You relied on this idea under this Hescock case that all they're doing is reducing nonconformities and therefore they don't need to show a hardship. But if you are enlarging either up or down within a setback, you have to show a hardship. And the Turek case from 2020 is the one that is on point. And that's one that we litigated down the street with the Tannenbaums when they sought to put a second floor addition on within the setback. You cannot extend up or down within the setback unless there's a hardship. So the point is, this is not an academic exercise. They are proposing to build, as far as we can tell, and by the way, we were denied the opportunity to come to a public hearing last fall because they misrepresented what they were going to do. But we believe the evidence shows that they are in fact enlarging. So you've got a two-pronged problem with this applicant. First of all, this absolutely is a condition of approval that they violate. Secondly, it's material because if these plans are what they're actually going to build, they are replacing what's a one-story structure at grade with a two-story, including the basement. And that's an enlargement within the setback. Now, why do we care? There's this massive excavation project going on at 8 feet, not even 8 feet, 2 feet from the property. None of which was accounted for. If they had come forward and been honest with their plans, we obviously would have asked the board to impose other conditions. Make sure that there's a geotechnical engineer involved who knows what the soil is. We all know it's very sandy down there. This is what people spend so much money on seawalls, hurricane sand with the problem. We are, of course, concerned about erosion, and that's not speculation.
Folks, can I jump in here? I want to reiterate what I said at the outset, that we're here for a specific purpose, and what I'm hearing is starting to sprawl.
Okay, well, anyways, I will then stop the sprawl and conclude that number one, the issue that was raised by council under the Anatra decision, absolutely, this is a condition of approval. It's been violated. Secondly, it's material because what they're now looking to do is an enlargement within the setback, which requires them to prove a hardship, which they had not before. Thank you for your time.
Thank you. Is there anyone?
Chairman, I just want to express my objection to
Okay, duly noted.
the
Duly
agenda
noted.
of the special meeting
Wait a minute.
and on the attempt to have a
Stop,
collateral
please.
attack
Your
on your
objection is
decision,
noted.
which is 6 months
Ms.
too late.
Nancy.
Thank you. And thank you for interrupting only me and not the gentleman who went too far. Thank you.
I was interrupted, actually.
Yes, please identify yourself.
My name's Carolyn Lyle. This is my third time that I've been watching this. I live on Sea Lane. I live 4 houses from this construction.
Are you a favor or against?
I would ask the board to stick to the regulations, to make sure that they are followed. My real worry is this is on the coast. And the basement that has all of that extra stuff is close to a seawall that's only 4 feet high. My seawall is 9 feet high. At Hurricane Sandy, my house was hit by the waves. I'm down the shore from this property. I worry about, I think DEEP needs to look at this. If it is in fact an enlargement, DEEP needs to look at it. CRAG hasn't looked at this new stuff. DEEP hasn't looked at this new stuff. And I want to make sure that you help protect the coastal management area and enforce the zoning regulations. That's
Thank
all.
you. Is there anyone else present who would like to speak? Is there anyone in the virtual audience who would like to say anything? Please raise your hand virtually. Okay. we're not going to have any kind of a motion. I don't think Mr. Bamonte was looking for that. I think he was looking for a sense of the commission, the board. And I'm sure he appreciates the additional perspectives that counsel from both people who are here, who represented the Shansky and Mr. Pittsy. I'm sure he appreciates that. So with that, I invite a motion to adjourn.
No, I don't get a sense. I mean, you would have to poll your members if you call it a motion or a vote.
We're not calling it either. We have had a variety of views expressed. My very clear understanding is that I am firmly of the view that this was an implied condition.
I agree.
Kevin?
6 times she mentioned it in the October meeting, so.
Yes, absolutely.
Attorney Bamonte, are you looking for an answer from each and every one of us, whether?
Yes.
There you go.
Okay,
So answer the question.
Laurie?
Would it have changed your motion in November?
Could very well have.
Andrew?
Now that I
It
know
wasn't.
that, now that I know that the slot on grade is going for full basement, I would say that's a definite change. It should have been.
Mark Hicks voted in November.
Yeah, I said it's an absolute difference.
Unanimous.
There you have it.
Very good.
Now, I invite a motion to adjourn.
Second.
You made the motion, you second. Right, all in favor?
Aye.
Any opposed?
More hand, I don't know.
We're adjourned.